There is creeping capture of the United Kingdom's judiciary. Earlier this week, at the Court of Appeal hearing of the Shamima Begum case, in which the defendant's legal team lost its bid to take its challenge to the Supreme Court, Lord Chief Justice Baroness Carr said it could be argued the decision in Ms Begum's case was harsh. It could also be argued that Ms Begum is the author of her own misfortune. But it is not for this court to agree or disagree with either point of view. The only task of the court was to assess whether the deprivation decision was unlawful. Since it was not, Ms Begum's appeal is dismissed. Baroness Carr was exactly right. The role of the judiciary is to interpret the law. Whether a judge thinks Shamima Begum was treated harshly or not, indeed, I think she was treated harshly, is entirely irrelevant. Parliament writes and passes the law. The judiciary interprets it in our courts. But this statement from Lord Chief Justice seemed to contradict the fact that earlier this week she took an explicitly political position with respect to Garrick Club membership, prompting the four old women we discussed yesterday to resign. A leaked memo seen by The Guardian said, "I wish to emphasise my commitment to diversity and inclusivity across the judiciary. We must continue our vital work in this area, including delivering on the work outlined in our diversity and inclusion strategy." It doesn't end here for the Lord Chief Justice. Not only does she seem to want to inject the judiciary with leftist groupthink, she also wants to take away from you one of the most basic of constitutional rights, the right to trial by jury. Under the guise of efficiency, Lord Chief Justice told BBC Radio 4 yesterday that as a means of clearing the court backlog, that consideration should be given to recalibrating which offences should be granted the option of being tried by jury or not. She acknowledged that this would limit the ability of a defendant to decide if they wanted their case to be heard by a jury. That is to say, limiting their fundamental constitutional rights. Trial by jury is an ancient right, confirmed in Magna Carta over 800 years ago. It is the cornerstone of the British justice system. And justice and efficiency are not necessarily bedfellows. In a competition between the two, justice must always win. There is a high risk that judges think they know it all and may become jaundiced by seeing too much evil in human nature. Juries may be more likely to find not guilty, although it could be that more often innocent people opt for trial by jury, trusting their fellow citizen more than an agent of the state. The English jurist William Blackstone once said, "It is better that 10 guilty men go free than that one innocent man suffer." But it seems the Lord Chief Justice is intent on turning the United Kingdom into a dystopian German-style legal system, where the ancient right of being tried by your peers is sidelined in favour of an elitist approach to justice with a sprinkling of woke ideology on top. As ever, let me know your thoughts, mailmog@gbnews.com. Well, I'm joined now by Joshua Rosenberg, the very distinguished legal commentator, who indeed carried out the interview. Joshua, thank you very much for joining me. How important is this, and is it a real threat to jury trial, or was the Lord Chief Justice just floating a kite?
I think the Lady Chief Justice was indeed floating a kite. Her starting point was the Conservative Party manifesto from 2019, in which the current government promised to establish a royal commission on the criminal justice process. She pointed out that that never happened during the present government. She thought it would be a good idea. She thinks some sort of major long-term inquiry into the criminal justice process would be a good idea. When I asked her what it might consider, she suggested that one area it could look at was what she called recalibrating what are called triable either-way offences. Either-way offences are offences that can be tried either by magistrates or in the Crown Court by a jury. Obviously, there are some offences that are so serious they must be tried by a judge and jury. Murder, for example. There are some offences, many offences, which can only be tried by magistrates. Some, such as theft, burglary, may be tried by magistrates, may be tried by a judge and jury. The defendant has the right to choose. And what Lady Carr said is that an inquiry might recommend moving some offences from those that you were entitled to a jury into the category where you were not entitled to choose trial by jury, although I suppose the magistrates could send you for trial by jury. That's what she suggested, but it's something that she personally is not backing. It's something that she thought a full inquiry into the criminal justice system might recommend.
But when somebody of her station starts floating ideas like that, it's an indication that it's something that she's open to, isn't it? It's not something that she would suggest if she were hostile to it.
I think that's fair. She would certainly be open to it. But of course, as you rightly said, Jacob, it's not up to her to decide. It's a matter for Parliament. This would require legislation. The government of the day would have to consider the recommendations. Past governments have tried limiting the right to trial by jury and have not succeeded. I mentioned this to her. She's well aware that this is a highly controversial topic. But nevertheless, it would be something that could be considered. As she said, many cases are already summary only, which means they can be tried only by magistrates.
But by and large, the summary-only ones are inevitably the less important ones, the ones less important to do fundamental damage to somebody's reputation and standing in society.
That's perfectly fair. And there are many people whose convictions for offences of dishonesty would mean the end of their careers. And that is why people, and you've made this point very clear, are wedded to trial by jury, regarded as fundamental, as a safeguard. But there are other offences which people think can reasonably be tried by the magistrates. After all, they have the power to send people to prison for 12 months if you're dealing with relatively low-level cases.
I thought 6 months. Sorry, I thought it was reduced from 12 to 6.
You're right. It was reduced from 12 to 6, and she says it should be put up to 12.
But that reduction, discussed that when I was in government at the time. Yeah. That wasn't actually about the prison population. That was about 12 months being a very, very long time to take somebody's liberty away for, without it being tried in front of a jury. That was part of the discussion that was taking place with people like the then Lord Chancellor.
I think the point about that was that if you have magistrates being able to pass sentences of up to 12 months, which is what the government proposed year before last and reversed last year, then you wouldn't have so many cases tried in the Crown Court. The magistrates wouldn't need to send people to trial in the Crown Court. And in those circumstances, that would reduce pressure on the Crown Courts and reduce backlog.
This is my biggest complaint, that this is being done for efficiency over justice, and to allow a stipendiary magistrate, a district judge, to send somebody to prison for a year is giving enormous power to one person.
That's right. And so that was reversed. The problem, of course, is that when magistrates could send people to prison for up to 12 months. That was increasing pressure on the prison population, not so much because people were being sent to prison for longer, but they were being sent sooner. And with the prisons so full and under such pressure, I presume that was the reason why the government decided to reverse that and restore.
As I say, in the discussions I was in, it was because of that fundamental idea that a year was a long time. But thank you very much, Joshua. Thank you for joining us and for your excellent interview.